Hello. So, for those of you who've been following my son's case, I wanted to offer you something to think about that's really important. And that's the number one reason why innocent people get convicted of crimes they didn't commit, and what we can do about it. So I've researched several hundreds of cases in the last 2 years, murder cases, essay cases, tons of exoneration cases, and the number one reason an innocent person goes to jail for, a crime they didn't commit, according to my research, is the innocent person did not know their case. When I say they didn't know their case, I'm saying that most people have no idea they have a right to see all the evidence the state has against them before trial. Now, your lawyer should have this evidence. They should be building a case around it. And the evidence is known as the discovery package. This is what the state has, and what they claim is the evidence that they found to be against you that supports their charges. So, what you always want to do if you've been accused of a crime is get a copy of your discovery package. Again, this is the evidence the state has that they claim proves your guilt and is the basis of their case. And guess what? The Constitution says you have a right to see this evidence. You have a right to see all the evidence, not just your lawyer, but you, the person being accused, have a right to see every police note, video, witness statement, police report, lab report, photo, fingerprint result, 911 call, body cam footage, police interrogation videos, hair and DNA analysis, phone records, satellite data. Any and all evidence in your case is your right to review and dispute. Now, your attorney should provide you with a copy of this evidence so that you, the person whose life is on the line, can fill in the holes and help draft your defense. Always remember that. You have a right to see all the evidence in that discovery package, and you have a right to see every motion that has been filed in your case, including motions that have been filed by your attorney. So I know some of you are saying, well, what if the state is hiding something? How are we going to know that the state is not releasing something if they're not releasing it? How do you know what's missing if you don't know what to ask for? In every exoneration case I reviewed, there were clues that the state was hiding something, but the defense dropped the ball. When they didn't ask to see this evidence for themselves, they didn't ask the right questions, and they did not go aggressively and assertively into defending the person who was falsely accused. There's no case that I've seen where the lawyer made sure all of this was done and the person was still convicted. I haven't seen it. So, for example, there's the case of James Dennis. He served 24 years for a murder that he didn't commit. When the district court finally overturned his conviction, it was after they found that there were witnesses who were called, and some of those witnesses were at first unsure about Dennis being the killer, but after seeing him not one, not two, but three times in different lineups, their memory somehow got more and more clear. This bias, being in a lineup that many times, is obviously going to create a situation where false memories are going to be triggered. And the state basically featured Dennis over and over again in these lineups, which automatically prejudiced the witnesses against him. But there were more major pieces of evidence that was missed by the defense in Dennis's case. One of the witnesses against him, who should have been one of his strongest witnesses, testified that she left work at 3 and ran errands before seeing him on the bus. Now, she just approximated that it was at 4 o'clock because she really didn't remember when. So when Dennis claimed that he saw her at like 1:30, 2 o'clock, when he saw her on the bus, She's saying she doesn't know. She just know when she picked up a check, and she received a receipt that was stamped when she picked up that check at 1303. Right before the trial, the defense knew that the state had this receipt, but they never looked at it. The receipt again was stamped 1303 military time, effectively confirming that she was on the bus at 1:30, just like Dennis testified. But this witness, when she was contacted later and confronted about the receipt, she admitted that she got confused by military at time and thought 1300 hours was 3 o'clock. Her confusion cost Dennis 24 years of his life. The star witness even told people she knew the boys who were responsible for the shooting were students at her school. But after police started focusing on Dennis, she changed her story. Police even got a tip from a jailhouse informant, and they knew the identity of the actual killer. And that recording and the phone calls and everything was hidden. But how well was it hidden? Well, when the woman Dennis saw on that bus was interviewed, she gave the police a timestamp for when she picked up her benefit check, but the attorney never asked, when did she provide police with that timestamp? Why didn't the attorney ask to see the receipt for himself? Why didn't the attorney ask the detectives how many people were interviewed the day of the shooting? And how many of those people identified Dennis as the shooter? Why didn't they make more of a big deal out of the discrepancy in the witness accounts of the height and the weight of the shooter, which was dramatically different from Dennis's weight and height? In case after case, police and members of the DA's office made a decision to hide evidence when a more assertive or more solid defense would have uncovered what needed to come out. What does that look like? So in one of the cases that I reviewed, there was an attorney whose client had accused police of SA during a traffic stop. When the DNA was conducted on her clothing and on her, they found no evidence. But the attorney was more diligent than that. The attorney actually went a little step further. So his client was being charged with making a false statement and was looking at jail time. And so her attorney did a more thorough search and found that there was DNA evidence there. And that DNA evidence was on the clothing of the police officer in his underwear. So he was able to get the state to drop the charges, and they settled out of court. The woman never told the police that she had been penetrated during her assault by the officer, and the evidence was always there, but a diligent attorney is what made the difference. That's what was that's how they were able to get a fair result. So knowing what's going on in your case requires that you view all the evidence and even confront witnesses against you. Again, you can do this before trial. So how does one do that? Well, everyone is entitled to what is called a preliminary hearing. You can confront witnesses against you at the preliminary hearing. What is a preliminary hearing? It is a hearing where you can establish your innocence. You have the right to call witnesses. You have the right to confront witnesses. You have the right to present evidence. In the state of Georgia, it's called a court of inquiry, and it's under Georgia Code subsection 17-7-28, 2020. So the court of inquiry is where, I'll read it for you. The court of inquiry shall hear all legal evidence submitted by either party. If the accused wishes to testify and announces in open court before the court of inquiry his or her intention to do so, the accused may testify in his or her own behalf. If the accused elects to testify, he or she will be sworn in as any other witness and may be examined and cross-examined as any other witness. The rules of evidence shall apply, except hearsay shall be admissible. So, this particular hearing is something that you are entitled to receive within 14 days of your arrest and within 21 days of your arrest if you are released on bond. I want to repeat that. This hearing is one that you're entitled to receive within 14 days of your arrest or within 21 days of your arrest if you haven't waived it, if you haven't been released on bond, or if you're released on bond but you still want to have this hearing. Most people have never heard of this hearing, and that's because the state knows how powerful this event is in a criminal case. This is what the U.S. Code says about a preliminary hearing at 18 U.S.C. subsection 3060. Except as otherwise provided by this section, a preliminary examination shall be held within the time set by the judge or magistrate judge pursuant to subsection B of this section to determine whether there is probable cause to believe that an offense has been committed and that the arrested person has committed it. B. The date for the preliminary examination shall be fixed by the judge or magistrate judge at the initial appearance of the arrested person, except as provided by subsection C of this section, or unless the arrested person waives the preliminary examination. Such examination shall be held within a reasonable time following the initial appearance, but in any event not later than the 14th day following the date of the initial appearance of the arrested person before such officer, if the arrested person is held in custody without any provision for release, or is held in custody for failure to meet the conditions of release imposed, or is released from custody only during specified hours of the day, or, and this is something I want us to make sure that we're aware of, all of these statutes, all of this is available to you as an accused person. In the state of Georgia, this hearing is called a court of inquiry. I have found 2 examples of the state literally denying innocent people this hearing and falsely stating that they received it. That's how powerful this hearing is. The only way you can legally be denied this hearing is if you waive it or if you're pre-indicted. That means if you're indicted before you're actually arrested. In DeAnthony Tolbert's case, and I spoke about him before, in DeAnthony Tolbert's case, his attorney told him to waive it. It was nothing. It took DeAnthony 4.5 years in jail to go to trial. He was acquitted of all charges when his trial ended in 3 days. A denial of your right to a preliminary hearing before you are indicted is grounds for immediate release. According to 18 U.S.C. subsection 3060, except as provided by subsection E of this section, an arrested person who has not been accorded the preliminary examination required by subsection A within the period of time fixed by the judge or magistrate judge in compliance with subsections B and C shall be discharged from custody or from the requirement of bail or any other condition of release without prejudice, however, to the institution of further criminal proceedings against him upon the charge upon which he was arrested. I really want us to think about how important it is for us to not only know the law, but know how it works and what to do about it when we do learn the truth. How do you petition the court before you're indicted to be released due to a denial of your right to a preliminary hearing? You have to file a habeas corpus in federal court. Now, this is only before you're indicted. If you've already been indicted, there's a whole nother process. But a habeas corpus is a civil suit that you file against the sheriff in the county where you're being held. The right to file a habeas corpus petition is so critical that you can legally ask your jailer for the pen and paper to write the habeas corpus petition, and they have to legally give it to you. You can also ask for the form and complete it using the document that they gave you. You don't have to even pay more than $5 to file this petition. And if you don't have it, let's say you've qualified for a public defender, it's free. Again, a habeas corpus is free for you to file. So I want you all to just take notes. If you need to, rewind this particular video so that you or someone you love will have access to this information. Now, if you're indicted within 90 days in the state of Georgia, but you didn't receive your preliminary hearing, your right to due process has been violated. If you didn't waive that hearing or you weren't pre-indicted and you did not receive your preliminary hearing, your right to due process has been violated. If you had an attorney and the attorney did not tell you that you should have received a preliminary hearing and then prepare you for one and make sure you got one, that attorney is not really on your side no matter how much you've paid them. Now, what can you do if you didn't get a preliminary hearing and you've been indicted? I can't give legal advice. I only give life advice. But the best way to proceed is to get a copy of your discovery package and file a motion for a speedy trial. Your motion for a speedy trial is the most powerful tool you can use if the state has violated your right to due process. The Constitution guarantees your right to a speedy trial, to a speedy and fair trial. A motion for a speedy trial must be answered within 2 terms of court. How do you find out what the 2 terms are? Google it. When you put in the terms of court in Georgia, you will see these results. And as you can see, you'll want to scroll down to the actual statute, which is Georgia Code subsection 15-6-3, 2023. So once you click on that particular code, you'll be able to scroll down to your particular district, area, city, and it will tell you the terms of court. So this is where you would find out how quickly you're supposed to be able to get a trial. Now, what a lot of you are going to learn, unfortunately, what a lot of you are going to hear from your lawyer is they're going to say they can't do a great job for you if you don't give him or her time to prepare your case. He or she will ask you to not request a motion for a speedy trial so that they have time to cover all the different elements and everything that's involved in your case. This is how people sit in jail for years. Some people even break and accept a plea for crimes they didn't commit. With a motion for a speedy trial, you know when you will go to court. With a copy of your discovery package, you know what the state claims to have and can prepare your witnesses and your defense. Always remember, you are presumed innocent until guilty. That means the person making the accusation has the burden of proof. You don't have to prove you didn't do it. They have to prove you did do it. That is their number one obligation. That means if they can't prove their case, they will try to suggest that you did it or imply that you must have been the one who did it, but that is not enough. The burden is on them to prove their case with evidence. What do you do if your lawyer refuses to file a motion for a speedy trial? I don't give legal advice. I'm only giving life advice. If your attorney, like any other person, doesn't want to do their job, What do you do? What do you do when anyone you hire doesn't want to do their job? So in the next video, I'm going to talk about the attorney who got my family for $4,300. His name is Dennis Scheib.